So I want to get to legalese, because this is a very confusing aspect, and I'm a big fan of like, okay, what do I need to know? I don't want to read a book on probate. I just need to know what I need to know about it. I cannot get through an entire book when I'm grieving. It's not going to happen. So the easiest explanation of probate ever is, probate is the manner and method in which the estate of the deceased is processed through the legal system. Period. Probate is the manner and method in which the estate of the deceased is processed through the legal system. So an estate is defined as all belongings, assets, and debts. The function of probate is to settle debts owed and transfer remaining assets to beneficiaries. That's my version of a book. So just so you know, all estates must go through probate regardless of the presence or absence of a will. The difference will be how the estate is dispersed. If there is a will, it is deemed valid and binding. If there is a will and it is deemed valid and binding, which is in most cases, the estate will be distributed according to the deceased wishes. If there is not a will or is deemed invalid, the estate will be distributed according to the laws of the state. Probate is done per state in the United States, so there is no federal oversight of probate. It's done per state, which means it's different in every state, which means you really, really, really need to consult a probate lawyer. The point of a will is to guarantee that your assets and belongings will go to the people and entities you want it to go to. If you think that your family will just figure it out on your own, you're gravely mistaken. My grandfather did not leave a will, and he left 3 children and his second wife fighting over money. They're very close. It was a very difficult situation for all of them. And it's kind of unless you don't care for your family, you just want to create a lot of chaos, then definitely don't leave a will. That's a good way to stick it to them at the end. So what happens on the flip side, if you don't leave a will, is that suddenly somebody's stuck holding the bag. In our situation, it was my dad. He had to, because he didn't have the legal paperwork in place, he had to fight with all sorts of companies and cell phone providers, and because even though he was truly the next of kin, he did not have the legal paperwork in place that would allow him to just say, close the account. That's as easy as it is. Like if you have a binding will and you are the personal representative, you can just simply hand over the paperwork that the court gives you and you say, close this account, close this account. So, which brings me to testate. If somebody dies with a properly signed, witnessed, and current will, your loved one is said to have died testate. Your loved one's estate will then go to the beneficiaries appointed, and the will must be entered into probate to be validated. That is hopefully the easiest way it goes. Intestate is if someone dies without a will or the will is deemed invalid, that person is said to have died intestate. His or her estate will then go to the lawful next of kin and settled according to the law of the state in which he or she resided. Much more trouble. In terms of what goes through probate, in general, all assets that are in the deceased's name alone will go through probate, such as bank accounts, stocks, bonds, mutual funds, vehicles, real estate, wages due, and commissions. If the deceased assets in different states or counties, such as real estate property, probate must be initiated in each county. In some instances, property in the same state may be addressed in the same probate filing, but state law varies, so be sure to consult an attorney. An attorney can be your best friend in this situation. I cannot overstate the importance of hiring someone who knows what they're doing, who knows the law. You can technically do all of this yourself in the same way that I could technically go and replace the transmission in my car, but I don't know a thing about it. And could follow some YouTube videos and maybe some pointers, but I don't think it's going to get done as well as if I go to somebody who does this for a living, who knows the law. And it's like having an accountant. I don't want to keep up on tax laws. I don't care. What I like to do is at the end of the year, I hand my accountant my information, and he does it, because that's his expertise, and I happily pay him for it. So, okay, so going back to probate, what doesn't go through probate? An estate worth less than $50,000, which I'm going to go into a little bit more, because if you have an adult child who dies suddenly, who's maybe 24 years old, maybe 30, they may not have assets that are worth very much at all. So I will circle back to that in a minute. Another thing that doesn't go through probate, properly jointly owned and registered with the surviving spouse. Assets that are contained in a trust, assets that have a named beneficiary, such as a life insurance or a death benefit, employer pension, which will go to the named beneficiary. So if you have a 401k account and you don't have a beneficiary, which most of the time they require that you name someone, if you don't have it, then the 401k goes through the probate. If you do name a beneficiary, bypasses probate entirely, goes directly to the person that you wanted to go to. Best way to do it. Same thing with life insurance policies. Something that's important to know about estate and probate payment is an estate must pay the creditors and the outstanding debt first. Then they pay estate expenses and fees. Then the estate pays lawyer fees. And then at the very end, if there's anything left, that goes to the beneficiaries or the heirs. So if for some reason, if you are the personal representative of a will, and you decide to change that up, that order of expense payment, which will be given to you by a court, the court will say, you must pay these expenses from the estate in this order. If you decide to deviate from that and you say, you know what, I'm going to pay the heirs first, and then I'll pay the debts, you will then be personally held financially responsible for that money. If the debtors are saying, wait a minute, this person still owes me $30,000, you're on the hook for it. So that's not going to happen that often, but I don't know how much they actually tell you that when you're going through this process. And something just to note about personal representatives or an executor of the estate, most people I think will probably be putting their spouses or their parents as the, and possibly siblings, to be their personal representative of a will. After the experience that we went through, normally I would have assigned my dad the honor of doing that, and wow, I have changed that, and I've given it to one of his friends, because here's something to remember, that the person who is managing your estate has to make a lot of phone calls and fill out a lot of forms and say over and over and over again, my husband has died, I have to close this account. My husband has died, I have to close this account. My husband has died, I have to close this account. That can be devastating. So you might consider for your, and again, it's all personal preference, but that is the role of the personal representative, is to close accounts, you're going to be living this world for a while of, my husband has died, I need to close his accounts. So consider, in my circumstance, I decided instead, after seeing what my dad went through with my sister, I asked one of his best friends that I knew that he would trust very much if he could please be the executor on my estate or the personal representative. because I didn't want my dad to have to do that again. He already did it with my sister. I don't want him to have to do it with me. So one more word about probate. People, I think, always think it's such a bad thing because it's it just seems scary, probate, like just overwhelming. There are some advantages to probate, and that is if an estate has many potential outstanding debts, probate imposes a finite deadline for creditor claims, which is usually 4 months. After that time period passes, no one can lay claim to the estate. And probate is also useful when handling contentious and potentially litigious beneficiaries. So again, everybody has a different kind of family, everybody has a different kind of family dynamic, but maybe you're dealing with Uncle Roy, Uncle Roy spends a lot of time at the track, and you don't know what Uncle Roy is up to. Uncle Roy probably owes a lot of people a lot of money. Maybe you don't want to deal with all of Uncle Roy's debtors. So if you can put Uncle Roy's estate through probate, you get 4 months, and then after that, too bad. You can have Uncle Roy's gambling buddy saying, like, Uncle Roy owed me $20,000. You're like, sorry, 4 months has passed, probate's closed. Tough luck. And one more thing is a word of warning. What happens when somebody dies, you do have to put in a death notification or an obituary to the local paper that serves 2 purposes. One is to notify your friends and loved ones of this person's passing, and also hopefully you can honor that person's life. But secondly, it shows due diligence that you have made a fair effort to let people know that this person has passed. And what you don't include in the obituary, but it's sort of silently understood is if this person owes you money, you need to get in touch. Let's see. So I would like to go back to the estates worth less than $50,000, because especially in this day and age, all of our estates, I think, are kind of going down. And again, if you're dealing with a younger person, again, adult children are a perfect example. There's a special affidavit that if an estate is worth less than $50,000, and this number varies from state to state, so you definitely would want to consult an attorney, you can file for a small estate affidavit, and it's sometimes called an affidavit of collection of personal property, and you can bypass going through probate, which can be a huge benefit. Because somebody like my sister, for example, did not have any assets. The idea of going through probate is kind of ridiculous because to settle what? But the deal is, you have to agree that you must pay all the liens and debts, you must pay all liens and debts, but you don't have to go through the probation process, which is helpful. And then the only people that are allowed to file such affidavits, and this could happen, this happens if you don't have a will, and it can also happen if you do have a will. The person who has, if you do have a will, your personal representative can file this affidavit and not have to go through the whole rigmarole of the probate court. And if you don't have a will, then those who have legal standing, such as the surviving spouse or children or parent, are eligible to file this affidavit. So it has to be signed and sworn in the presence of a notary, and then it's filed with the probate court. So the affidavit can be presented to creditors directly to prove that the person listed is serving the interest of the estate. So if my dad had this, it would have been a lot easier.